I want us to take a quick look at intellectual property. I don't know if you could hear that, but pardon me. So just do a start over, but I'm not going to. Patents, copyrights, trademarks, et al. This is a mixture of federal and state law, but let's begin. You see, I've really worked hard on transitions and everything else. Hopefully, an American audience knows who this individual is. Benjamin Franklin, one of our great scientists and inventors, a statesman. I believe the picture on the left is him in a coonskin cap in France, where he was extremely renowned. The French loved Franklin. He had invented the bifocal. He'd done all kinds of new things. The Franklin stove still exists. And I think he's the one who put in Article 1, Section 8, and I'm not sure which section of it, subsection this is that we're dealing with, but Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And the asterisks are something we learn in the law, that that's how we do the ... on a block quote. If you look at this, this is Franklin's language. Franklin, I believe, was at the Constitutional Convention. John Adams and Thomas Jefferson were not. Hamilton left. He went out into the states to try to promote it, and leaving Madison to draft it all along with the other people, and George Washington was the president. But this is a very powerful provision of our Constitution. One of its problems nowadays is that a lot of foreign countries don't recognize American patents, or they think they can just copy our goods, and we'll not be able to do anything about it because we'd have to have our army go in and enforce it. I won't name names, but there is an ancient kingdom that does this stuff. All right, so we got all these lovely drum rolls. This is probably a joint session of Congress. This looks like the president addressing the Congress. And this Constitution, Article 6, shall be the supreme law of the land. So any laws coming out of Congress pursuant to the powers granted it under Article 1, Section 8, which is the primary power source in the federal government. We gave Congress all these powers. We give the executive powers to execute the laws Congress puts in, and the courts have the powers to interpret those laws given the facts and given precedent. So I find these, maybe I should turn them off, but so the big deal that we're dealing with here is what we would call intellectual property. First of all, patents. There are two types of patents in the United States. That's the product themselves and the processes. People have been able to patent their sales processes. It has to be unique. It has to have something that's different from another. But if we look at American patents, the numbers are huge. And so slight differences can make a big deal. The patent I always like to talk about are some of Westinghouse. At one point, Westinghouse had, I believe, 87 patents to himself, including the knuckle coupler, but he's got light bulb patents, a whole bunch of things. Generally, the corporations own the patent. The scientist works for the corporation gets the title to it. So Kodak, for instance, I believe had over 5,000 patents. But part of the problem they're running to is that, and I didn't follow it all the way through. Kodak had itself up for sale primarily on the idea that its patents had a lot of value. Well, it was the one who created digital photography, but then it didn't do anything with it. It wanted to stay film. Well, it's in big trouble now. But processes, how do we get to this point? Like the process of running a manufacturing line, the process of getting a auto body ready for paint. there are ways we can do this that would patent it. One of my favorite authors, William Blake, had a printing process where he etched, I believe it's bronze plates, and printed off them, and then he and his wife hand colored the resulting books, because he always illustrated his poetry. And the interesting thing with him is that because they hand did it all, no two books are perfectly alike. They would, the colors would always change from day to day. So very interesting. And nobody's been able to recreate his printing method. He didn't write it down. And one of the things we can do in a process type patent or product type patent is we can actually, the problem is we are now publicly going there, and this is where Coca-Cola doesn't, its process, its intellectual right in its recipe and its formula is not public because people can engineer to it. They can kind of reverse engineer your product, but they've been able, that's a trade secret, they've been able to keep that a secret for almost 90 years, maybe longer. But if we have a patent or patent pending, we have to tell people, hey, I've got a patent on this. The way we put these together, I've got a process patent on it. Copyrighted material, generally patents last about 40 years, but they can be renewed. Drug patents, first issue, only last about 5 years. It's part of the reason original copy drugs are very expensive, because we're the only country that really tends to protect this. Most of the drugs are developed in the United States for a market that will actually pay more than fair value for them, so that they can then be disseminated to the rest of the world at a much lower rate. That's not very fair, but at least we tend to have cutting edge medical care. The rest of the world has to wait till we innovate it. Not completely true, but 98% true. I think we have 100 medical Nobel Prize winners, and the rest of the world has 22. Britain has 5, and they're the closest of anyone else. Copyrighted material can be renewed. It used to be that it would expire after 40 years, but now it can keep going. So J.K. Rowling maybe can set up a relatively permanent trust, and we'll see this with more modern authors. They're going to, I believe that Faulkner's work continues to be copyrighted, and he may have given it to the University of Mississippi at Oxford, which is where his home is. And so his family gets a little bit of income off of it, and then the university gets a balance of that income on everything that's sold. Trade secrets. The big deal here in a trade secret is you've got to govern it yourself. You can't be laving this around on your administrative assistant's desk overnight. It's got to be kept under lock and key and carefully guarded. There are a number of these, like Hunt's Beans, processes at sales that we particularly do. We may have found a way to penetrate the first barrier of resistance at certain organizations. Well, that's something we want to keep in-house because it works well for us. But in order to keep it a secret, we have to be active in protecting it. Let's go to trademarks and service marks. A trademark is, the Coca-Cola bottle, the Coca-Cola label. Pepsi has one. This one there's places where the states can do this too, and I'm a little fuzzy in this. Same thing with a service mark. That is the difference between the two. I'm a little fuzzy on, but we can register these. Now we're going to register it with a government organization. They're going to keep a copy of our, much like the patent, copy of our trademark, copy of our application. It's going to tell people shape, design, dimensions. It has to be very specific. For those of you thinking about going into law, intellectual property law, particularly patent, trademark, service mark, is relatively lucrative. And oftentimes, at least for patents, you need a science background. So it's kind of a limited field of competition because it's only scientists who can get into it, and not every law student, I assure you, could graduate with a bachelor's degree in the sciences. But much like actuaries, patent lawyers tend to be pretty happy people because it's do the work, do it right, make sure it's right, then triple make sure it's right, and then you can take care of it. Now, the big deal in intellectual property is you have to take action to protect the right. If someone infringes on your patent and you don't go after them, you may have waived the power of the patent. So that a later infringer may go, wait a minute, we thought it had become public because here these other people used it, they didn't object, boom. And while we want these patents in place, we also don't want them. They're kind of a hindrance to development, if you will. Going back to Westinghouse, I believe his knuckle coupler on trains is basically the same thing he patented back in 1874 or 1876. It's the same device. They've just slightly improved on it here and there, but it's pretty much the same thing he designed way back when. So, we're talking 130-year-old patent. Has it stopped others from trying to do it? Not really. The problem, though, is he got it right the first time, and nobody outside of the holder of the patent's really been able to improve upon the patent. And since they have the original patent, they've got a better ability to improve upon their own patent and add patent to patent to patent to patent. That's why I remember my Rawlings baseball glove. I think it had 7 patents on it. As I looked at it, I'm like, wow, that's a lot of patents for a bunch of leather. But there were things that they were doing in the process and the product that they wanted to protect. It probably was the nature of the cowhide, that sort of stuff, the stitching. I don't remember, it doesn't tell you on the glove what the patents are, but it does identify them by name and number, or by number, and you can go to the patent office and find it out. This is another area where we get treble damages. All right. So general damages is if I infringe your patent, all of my profits get taken back from me. All right. And this is, think about it. Why would I infringe your patent if I'm not going to make money on it? I also would be liable for any damages suffered by the holder. Maybe you infringe on the patent, build a not quite as good an article, and then it hurts our sales too because the knockoffs are junk. One of the things we can do is we may force you to go get all of your goods that you've sold, bring them back and destroy them, get rid of them. Or earlier thing, and we see this a lot, we're going to have an injunction filed as soon as you go to market. We're going to go to a court. This infringes our patent. Please put an end to it. The standard on an injunction, stopping someone else, is a kind of a low barrier. It is, am they likely to prevail at trial? Well, if you're holding a patent and we bring the 2 articles in and put them side by side, and the judge looks at it, he may go, I'm going to grant this until you can prove me you're not infringing. We're going to shift the burden to prove over to the party who is infringing. The treble damages, that is, we will triple these numbers up above to award, so if Kodak has a digital patent that's being infringed upon by Samsung or Apple or someone like that, and they're doing it with the intent to step on the patent, which is hard to prove, granted, but with depositions, with everything else, all we need to do is find one disgruntled employee or one employee who feels like, it's my duty to tell the truth, blah, blah, blah. We may get there, and all we need is some evidence to get to a jury. With the threat of treble damages, we may force, if nothing else, a higher settlement than we would have had to force otherwise. But these treble damages are really meant to say, look, they went to all the trouble to invent. They are entitled to the process of their invention. This is something guaranteed to us in the Constitution. This is a rule of law that we hold dear here in the United States, that authors and inventors get credit for what they've done, that somebody can't just steal their stuff. And so that is the end of it. Hope you enjoyed it. Thanks.